So welcome everybody. Sorry we're a little bit late. You know how technology is. Some days it's magical, some days it's not. But I am so excited today because we have two wonderful guests with us, and they're going to be sharing all about their new book. And I don't have the hard copy, but I do have the book on my Kindle. Do one of you have a book that you can share? I've got a
Here it is.
Yay! So Jen, you want to tell us the title?
Yes, the title is Your Special Education Rights, What Your School District Isn't Telling You.
So this has just been published. It's like already on its second printing because it's been so popular. But I am just thrilled that Jennifer and Julie are both with us today. Jennifer Laviano is a sought-after special education attorney from Connecticut. And Julie Swanson, you want to wave, Julie? is a professional special education advocate. She's also a parent. And this dynamic duo has been known to be referred to as the 1-2 punch. And I think you'll find out why today. So if you've ever been frustrated because you just know either your rights or your child's rights are being violated, and it's like, what can you do? How can you figure this out? Well, today, Julie and Jen are here to help you with that. So if you're with us live, type in the comments yes, and that you can hear us. If you're watching the replay, know that you can come back and also make comments and ask questions. If I don't know you yet, I'm Charmaine Tanner. I'm a parent, a retired teacher, a professional advocate, and I'm thrilled that we can be here and help each other grow so we can even become better advocates for our kids. So I would just love for Jen and Julie maybe to start us off with why they felt the need to write this book and what were some of the experiences that they brought to the book.
Julie, you want to start?
Well, sure. I don't think a day goes by that Jen and I don't hear from parents how completely overwhelmed they are by this process. There's an information overload. And, I remember back to the dinosaur days of when my son was diagnosed with autism about 17 years ago. And it was before there were computers, and I actually had to go look up everything at the library. So we've gone from sort of that absence of information to what we would consider an overload of information. There's so much information on the IDEA, on websites and books, and so many parents have told us that it completely overwhelms them. And so one of the things that we did to address that is we have a website called yourspecialeducationrights.com, and that's a video-based website that helps parents understand their rights simplified, broken down into digestible video components. As far as writing the book, we still think, even with our website, there's a lot of fog. And what we don't often address is what our school districts aren't telling us. So that's why we wrote the book. But I'll let Jen pipe in too.
Yeah, so I think over the many years that Julie and I have been working together on these types of projects, the book has kind of been writing itself for a long time. And we just finally were able to get ourselves together to really pull it together. And one of the things that parents say to us over and over again when we have mediations with them, IEP meetings with them, is when we explain what's actually happening and why they're in this predicament, and now that we know what's behind the scenes, they say, gosh, I wish I had known that from the beginning. If only someone had told me this 5 years ago, I would have not done this, would have done this, and this. And one of our goals is to shorten that learning curve for parents, that they don't feel like they're only figuring out this system when their child's about to be exited from services.
Oh, exactly.
Well, the other thing too, Charmaine, just really quickly is, what you don't know as a parent can hurt you, and ultimately the outcome of your child's life as an adult. It can end up in a deprivation of services and perhaps even losing out on critical skills. So what we don't know can actually hurt us. And so we're hoping that that book takes a stab at that.
Oh, it does. And I've just really, even as an advocate, I've enjoyed reading the book. So I think not only parents, but other advocates can get a lot from the book. If you would like to get the link for the book, just type the word book in the Facebook comments and we'll give you the link so you can make sure that you can get that book. Either you can get a print version, a Kindle version, and the print ones will be available in a few days, right?
Yes, the second shipment's supposed to hit the warehouse the 28th is Monday is what we're told. So we're very excited. Barnes & Noble and Amazon.
Cool.
And Charlene, by the way, Charmaine, that is a lovely compliment coming from a parent and an advocate for you to say that about our book. Thank you.
Yeah, I do. And I wanted to share one of the quotes. It's near the beginning of the book, but it really resonated. And I just like how both of you have given different scenarios. And then you have the section on, what the district isn't telling you. And then the next part is what you can do. And so Jennifer and Julie have, sample emails that you can send, suggested, conversation that you can have. So it really is a hands-on book that you certainly want for your toolbox. But one of the quotes that I liked at the beginning says, you can't use logic to talk someone out of a position they didn't use logic to get into.
Yeah. One of my favorites.
So if you could elaborate on that.
Yeah, I sadly probably say that to clients about once a week, if not more often. Well, one of the things that the book does when we peel back the curtain of special education is talk about some of the behind the scenes politics and legalities that are happening in schools that parents are unaware of. That is, in fact, what's leading to the decision, not what seems to the parent to be a totally arbitrary and illogical answer that they're getting to what they think is a very reasonable question. And we give a lot of details and specific examples, but one as that jumps out at me, and it's one that is truly illogical, is the situation where a parent is looking for a private school that may not be on the approved list of their state, and therefore that IEP team won't place the child in that program, even though it's less expensive and everyone agrees it's appropriate, and instead propose a very restrictive, much more expensive program, and the parents pulling their hair out and saying, I don't get it. Everyone says this is the right school and it works and it's cheaper. I don't get it. Or in fact, the issue is that the school district has a bus going to school A, but not school B. And the parent wants school B and the district wants school A, and the parent doesn't understand that it's because there's significant cost sharing if two kids can be on the same bus. And if you don't know that those are the kinds of behind the scenes factors which really do go into these decisions, you're often befuddled, and it can really erode the trust between the parent and the school district, in my experience, because they just feel like they're being told no without understanding the basis for it. So that is where that logic piece comes in, where parents will say to me, but it doesn't make any sense to me. He would definitely do better here. And I said, they didn't use logic to get there. Don't make yourself crazy. Don't use logic to get out of this situation. They didn't use logic to get there. This is what's really happening.
That's great. And Julie, do you want to add anything to Jen's examples, or?
Well, I don't know if you covered the fact, Jen, where when you've got private school A and private school B, and A is less expensive and everybody agrees they should be at A, why they weren't at B. I think you might have, it comes down to the fact that they weren't a state approved school.
Yeah, I talked about that, but I probably spoke too quickly.
Okay. Oh. So I just didn't know if that came through. I'm sorry.
Yeah, it's okay.
You're fine. So, and I think that is frustrating because, especially a lot of parents that feel like, this is how it's supposed to work. This is what I've read on the internet or whatever. And when it doesn't fall into sync in those steps, in those logical steps, it's like, they just kind of throw their hands up. So what would be a way to help the parent, like you, so you've identified that illogical thinking that got them to this place, but then as you're in the IEP meeting, what can you do, what kind of conversation can you have to bring that back around and try to engage?
Yeah. And of course, just like with every child, it depends on the individual's circumstance. There are some things that are not necessarily best handled in an IEP meeting when there are outside factors. And that's something we talk about in the book as well, is sometimes it's time to have a one-to-one with your special ed director. Now, the law is quite clear that there are certain decisions that are supposed to be made at that IEP team, but that doesn't mean that's the only time you're allowed to communicate with your school district. And if in fact what's happening is that the school district feels constricted by the non-approval of a school, as an example, or constricted by transportation, the parent may be very happy to drive the child. I have many clients who would actually prefer to do that. And so in a one-to-one meeting with the director to say, look, I know at the meeting you proposed school B and I wanted school A. I now know it's because you already have a bus going to school B. If you pay for school A, I'll drive him there. You may be able to do that outside of the IEP process through a written agreement. And, it doesn't necessarily have to be a written contract, the kind that I negotiate on behalf of my clients all of the time. But there are ways to address it that way. One of the things Julie and I are just very passionate about in the book and in our advocacy is parents have to document these things. When something is occurring at the IEP meeting or in your child's education that is, you believe, a violation of the law or your rights, and that information overload Julie referred to, we caution parents that just because it's online doesn't mean it's accurate. And just because you read it doesn't mean you 100% understand it. We have, a lot of litigation because people don't necessarily interpret the same language the same way. But we want you to make sure it's documented. Just having a chat with somebody in the hallway is not an effective way to set up a case in the event that you have a legal dispute, because if it's not in writing, it didn't happen.
And that leads me to talk about something that a school district may not tell you. And it doesn't always mean that if a school district doesn't tell a parent something, that it's intentional. But they just may not tell you. And as an example, when you're in an IEP team meeting, your parent concerns are incredibly valuable, and documenting those concerns are incredibly valuable. So it would behoove parents in a situation like that, when something arises and you're not comfortable with it, to say, I would like this parent concern documented on the record. Now, each state's IEP paperwork is designed very differently, but there should be something on your state's IEP paperwork that says parent concerns. It may be called something else. If it isn't on the IEP paperwork, then you say, I'd like to create a spot where you could document my parent concerns, and literally tell them what your concerns are and get it documented. This brings up another point that a school district may not tell you, that you can audio tape your meeting. Now, there's a little caveat there. Not every state allows you to audio tape a meeting, so you have to check with your state. But that may not be something that a school district will go out of its way to say. I know in our experience, Jen and I feel very strongly that audio taping a meeting can be incredibly helpful, because as a parent, you're so overwhelmed by what's going on that you don't even have the wherewithal sometimes to write down what's happening while it's happening. But if there's an audio tape, then everybody can check what actually happened at the meeting. So again, those are, just two examples of things that a school district may not tell you. That's very important for a parent to know.
Oh, exactly. And I often will say, don't let the forms drive the process. I mean, when I say, we want that added to the IEP, and they say, oh, our drop-down menu doesn't have that. And it's like, no,
yes.
We're not computerized form drive the process. So I say, true. Click, there should be another box there, or type and the box will expand. But so
we actually have a chapter called there's a form for that. I think we have a chapter called There's a Form for That, where we talk about some of the perils of our form-driven society.
Another thing we talk about in the book is a school district may not tell a parent that they can actually write an addendum. So if you get the IEP paperwork back and you say to yourself, was this the meeting I was at? It doesn't even reflect remotely what we discussed. You can write an addendum. And in the book, we step parents through that. And again, we don't have an exact form for that because you have to realize that every state is different. But there's a logical process to follow because typically IEP forms and paperwork are in categories. So you look at each category and you say, dear team, and list all the members on the team. Under this part of the IEP, it says this is inaccurate. Will you please, have it reflect ABC? So that's another thing parents may not be told.
And let me give a welcome and a shout out. We've got several people watching this live. So Jen and Angie and Murad and Eileen have joined us. And I know we have some other people on here that haven't said hi yet. But let me put my glasses on. I'm like, Jen, I've got to have glasses on. Because we do have a question here. So let me see if I can bring it up. But while I'm looking for Eileen's question, if you want to get the links for their book, Your Special Education Rights, just type in the word book in the Facebook comments. And so Eileen says, would you have them address their opinion of RTI and how that system can deny or delay children from appropriate service because they're making minimum progress?
Sure.
So Jen?
Julie, you want to go for it or you want me to?
No, you can start. I'm taking a deep breath. I'll wind up after you.
So, we all we're all a little guilty of getting into the business of alphabet soup in this field. So RTI, just for those who may not know what it is response to intervention, which is supposed to be a regular education intervention that was put into the IDEA, which is the Individuals with Disabilities Education Act, the federal special education law. And RTI was supposed to be so that we were not identifying children with learning disabilities who in fact had not received scientifically based intervention. And it could be the subject of not just one of your shows, Charmaine, but certainly an entire law school course in my experience, because it's very complex. And so I don't want to, try to suggest that I can possibly cover it all here. My concern about it has been from the beginning, other than the fact that it really was designed for those children suspected of learning disabilities and has magically transmorphed into now we address RTI for all suspected disabilities, which is an entire whole conversation. My other concern is that it is often used to delay identification and, more importantly, referral to special education, meaning that a child will be placed in one of these response to intervention programs and languish for sometimes years in that program without being referred to the IEP team for a comprehensive evaluation in all suspected areas of disability as required by law. Now, both the federal government and many state governments have made it abundantly clear that RTI is not supposed to be used for that purpose, and it is not supposed to delay referral. And in the book, we do address this concern somewhat, although, again, it could be its own book, which is if you're being told as a parent that your child can't be referred for an evaluation because they haven't completed tier 1 or tier 2 or whatever tier they're on of the RTI system, that's simply plainly not legally tenable. If you want to refer your child for an evaluation under the special education laws, you have a right to do that, and you don't have to wait until the RTI process is over or has reached a certain point. That's a very global way of understanding a very complex issue, but I share whomever asked the questions concerns about RTI and how it's being used despite its, I think, pretty good intentions.
And in my experience, I often find that parents are sometimes not even aware that their child has been in RTI, and they are supposed to be informed. Also, I don't think that all educators understand how RTI is supposed to be used. And so when it is abused, it's not always intentional. And as Jen said, kids can languish in a tier for way too long. But I think the takeaway, if I had one for parents to know, is that you don't have to wait to go through all 3 tiers before being referred to special education. You can skip the line altogether and say to your school district, I would like my child to be referred to special education, and I want you to evaluate him or her in all suspected areas of disability. So there's lots of urban legends around RTI, and that's another chapter in our book called Urban Legends, things that people say, and sometimes teachers say things in IEPT meetings, and they think it's so because everybody's done it for so long, but in fact, it's not. As an example, we talk about in our book that often people will say, well, that's our policy. And if you dig a little deeper and you ask for the written policy, in fact, 9 times out of 10, there is no written policy. In fact, it's just a practice. But these are some of the urban legends that go on in school districts, unfortunately, with no malintent most of the time.
Right. And I think that's a good point. I think sometimes it's those unintended consequences that we are left dealing with. But I think, the majority of teachers that your children are going to have are going to be coming from a place where they do want to support your child. And sometimes they just don't know exactly how to do that in the most appropriate way. But looking at RTI, and so it made me think of, and I can't remember which OSEP letter it is that clarifies how response to intervention can't be used to delay identification. But as far as an advocacy strategy, do you suggest to parents that they use outside information like an OSEP letter that they could bring to the team if the team doesn't really understand what the process is really supposed to be like?
I would say always. When you can bring in written authority from OSEP or the Department of Special Education from your state or from the feds, all the time, because that gives some weight to, it's not just your opinion, but you've got written authority from somebody from a higher level.
Right.
And I would say,
helpful.
Words like always are just troubling to me. And Julie and I, we worked together so long, and she knows I can be so picky and a pain in the butt because I'm a lawyer. And so
I do.
You didn't do anything wrong. I'm saying with the following caveat.
Okay, go ahead.
Which is just that, look, it can be a great thing for your school district to be aware that you are researching your rights. And if you show up with an OSEP letter, they're certainly going to take a lot more time and pay a lot more attention, because it's quite clear that you've been doing your research and that you're not just accepting the answers you're getting at face value. And there is value in that, and it's some very good value in that, within reason. And I say that just because I've seen some parents who go so overboard with that information overload that they'll walk into an IEP meeting as if it's, a briefing of a piece of litigation like a paralegal, and you may not actually understand all of those letters. And I'm not saying that because I think you have to be a lawyer to understand all of them. I certainly don't believe that, but there's a reason that we have training as attorneys. And what I worry about sometimes is that if a parent goes in with a whole bunch of information and they're dead wrong on whether one of the 12 letters that they've shared is applicable, their credibility gets undermined. And so with everything within reason is just my point.
Oh, absolutely. And, we have a chapter that is called Finding Your Advocacy Style, and how you advocate and how you present your information to a team is incredibly important, to Jen's point. And, parents, we have many parents who are attorneys who we work with. And so it doesn't necessarily mean that you're going to approach everything with that over the top. I'm not saying that attorneys are over the top. I didn't mean that at all. But, that information overload approach to things.
Right. And Venus from New York City has just joined us, so welcome. And so, Jen, can you show us your book again, because she was wondering about your book?
Here we go.
So there it is, your special education rights, what your school district isn't telling you. And Venus, if you just type in the word book, I'll give you the link as soon as the show is done. It's both on Amazon and at Barnes and Noble. So it's very accessible, and I encourage everybody to add this book to their library because it really cuts through kind of the jargon sometimes that exists in IEP meetings and really simplifies and gives you, just real life scenarios that have happened. And so it's very valuable, both for parents and I really think for advocates too. So I'm going to quick check my phone and see if we have any other questions or comments. Yeah, and Venus was saying how so many times parents are intimidated when they walk into that IEP meeting.
Mm-hmm.
Yeah, well, that's for sure. In fact, there is it's rather amazing to me how effective parents can be on their own. I kind of I'm in awe of so many of the parents I encounter because I walk into that meeting and I've got, a whole background, over 20 years of doing this, and it's not my child, which, many of the attorney clients I represent will say, well, if I research it, I still realize it's my kid and I can't be objective, and that's a wise move. But I walk into these meetings and there's sometimes a dozen or more people representing the school district and then the parent, sometimes alone. And it can be incredibly intimidating. And the vernacular is confusing, not just the legal vernacular, but the educational jargon can be very confusing, which is why I'm grateful to Julie very early in her and I working together. She encouraged me to stop just throwing out terminology without defining it. And I try to even the IDA, every time I say it, I try to say, which is the Individuals with Disabilities Education Act, because it's adding to the intimidation factor for families to constantly feel like they're not sure they understand what's even being said in the room.
Right, right. And I know, Julie, as a parent, it feels so different when we're there in the parent role instead of the advocate role. And it does give you a whole different sense of what other parents are going through every time they walk into that conference room.
Sure.
Well, and somehow I can never really escape thinking that every child I work with, I pretend is my child. Mm-hmm. It's very hard for me to get out of that role because that is a role that I live. And, I don't, perhaps that gives me an advantage. But I do think of every client, every parent, every child I work with, I pretend this is my child, and I try to bring that passion to every case that I work with on, I should say.
Right, and that's true. I mean, it's like, you just bond so much with the family when you start working with them as an advocate or as an attorney, and you do have that sense of justice and that you want all kids to have that. And so that, I think, shines through when you have a passionate attorney or an advocate to kind of be your guide on the side. But I know Eileen had made another comment, and she was the one that had the question about response to intervention. And she said that that Tennessee uses it for identifying specific learning disabilities, and that it's really frustrating for her. But what I can do, Eileen, is I'll look up that OSEP letter that I'm talking about, and I'll give you a link to the PDF. And if that's not something that you have now, that could be something that you use during the school year if you want to have that conversation about making sure that your child gets identified. I mean, there's other aspects you can look at too, as far as child find, and as your district identifying your child under child find. Jennifer or Julie, I don't know if you want to speak to identification and how parents can also use that.
Sure. So Child Find is an affirmative obligation on school districts under the federal law to identify and evaluate. Well, evaluate and identify would be the preferable order of that, students who have disabilities who reside within their school district, even those students who don't attend the public schools. And it's a very, again, like anything in the law that we're talking about today, some of it can be very complex. But what's important is that affirmative duty, but because what it means is that it's not up to the parent to have approached the school district, although they have that right, to refer a child for evaluation if the child is suspected of having a disability. The obligation is on the school to find students who have disabilities residing in their district and evaluate them, and then identifying them if they meet criteria. And unfortunately, to this day, even after all these years of this statute that we've had and all the training that we know schools obtain for their educators, I still get phone calls every week from parents who have children who had pretty obvious special education needs that were never referred for an evaluation. And sometimes they can be among the more upsetting cases from a parent attorney or advocate perspective, because you literally can see children who have had most of their education wasted, and the consequences can be truly disastrous. I mean, life or death disastrous for some of these children. I've had a number of cases where the outcome was pretty horrible for the child because there wasn't an effort made to refer them for an evaluation despite clear and ample evidence that it should have happened. And some of that, as Julie and I are we really want to convey this message because we do think it's very important. We know educators are not, getting into the field of education to set out to mislead parents. That's not their goal. And in fact, one of the ways we know that is we get a lot of referrals from educators who say, I'm concerned about your child, and you didn't hear this from me, but this is a lawyer you want to call, or this is an advocate you might want to call, because they're concerned. And so, what happens is these fallacies and these urban legends develop in special education so that many educators don't even realize this is actually a child who might be covered. A very classic example of that, and one we see a lot, are students with emotional disturbance, which is one of the categories under the special education laws, where because the student may be, as many students who have received special education are, very, very bright and do very well on standardized testing, but in fact are not regularly attending school, have significant social or coping skill deficits, and are really struggling, sometimes hospitalized frequently. And because the kid's so bright, it's not triggering something in the teachers to refer the child for special education, because we still have this antiquated view of special education that it has to do with intelligence, which it does not in almost all circumstances. So, Child Find is an area that unfortunately still requires a lot more understanding. And in my view, and I've expressed this to legislators and I've expressed this to policymakers many, many times, part of the problem is that most of the people who get training in Child Find are special educators and related service providers who work with children with disabilities, which means you're training the educators to find children who are dealing with the children who have already been found. Okay, we need to be training regular educators on Child Find. That's who needs to understand what some of the signs are that this, in fact, is a child who requires a referral. But I'll get off my soapbox.
And Charmaine, we wrote this book primarily for parents, but we would really think that educators, administrators, and people who work in related professions in the school would really benefit, because it's often our experience where we find out that educators don't know many things about the IDEA. And it sounds terrible. It's another thing that what your school district may not be telling you, is that there's often enormous pressure on educators who, in some cases, we have heard, can be told, we can't identify any more kids this year. Like, they've tapped out of their resources and they're sort of under that direction. And we have a chapter in our book called Teachers Need to Eat Too. And so while teachers, we know, get into this field because they love kids and they want to help kids, they're often under enormous pressure, which I'm sure is not always pleasant for them. But these are some of the things that we've learned over the years, and it's unfortunate. And by the way, I just want to make it very clear, when we even addressed this in our book, we didn't write this book to bash school districts. We're both products of public schools. We love our public schools. And one of the consequences we hope comes out of writing this book is that we can't change the system if we don't talk about these types of things. And the more that, because I'm a firm believer, you can't change somebody else's behavior until you change your own. And so it's what you bring to the table that's going to perhaps change the behavior of other people. And so, some of these things are very uncomfortable to talk about, but we should be talking about them because parents need to understand what really happens behind the scenes.
Oh, exactly. And one of my mantras is the 3 R's of advocacy are relationships, relationships, and relationships.
Yes.
And I think when we develop those relationships
So true.
with the teachers, the principal, the director, whoever, then we get to understand more of where they're coming from. And it helps us communicate better when we do have a relationship outside of, just I'm a parent, I'm going to be demanding this, you're a teacher, you're going to be refusing this. But there's really underlying, it's like that tip of the iceberg kind of thing.
Charmaine, we wrote a chapter about that too. And it's called, your special education director may not know who you are. So go ahead and introduce yourself. So often when we go to IEPT meetings, parents don't know who's chairing the meeting, who the decision maker is. And depending on how big your school district is, there are school districts that have a head of special education with, 10 people under that person. And there are small school districts where there's only one person. But the fact of the matter is, it's, as you said, relationships, relationships, relationships. Introduce yourself to that person and explain what your child needs are. Say you'd like to have a meeting with them. Ask them to come to your IEPT meetings. But you've hit the nail on the head there, for sure.
And one of the things that I wanted to address, because I think parents feel this underlying, kind of tone to the meeting sometimes, especially towards the end when you're talking about services and supports and maybe placement, where decisions are really being made based on financial whereabouts versus what your child actually needs. So I know in the book you talk about how money is often a factor, even though we know that districts aren't supposed to use that. But if parents suspect that, what would be some ways that they can have that conversation and try to clear that up?
Julie, you want to talk about it?
Well, sure. I think one of the things that, from a practical perspective, that I will always do, and we actually address it in the book as well, is if money does come up, to very politely at the IEP team meeting, to call it out and to say that, it's your understanding that money is not supposed to be a driving factor in decision making, and that you're very uncomfortable with that, and that you'd like it recorded under your parent concerns as, just one option. And I know Jen can probably add to that.
Yeah. And, if you're not feeling as if that concern is being properly recorded, email is a lovely thing. And following up an email to whomever chaired the meeting or who was the administrator to say, I just want to reiterate the concern I expressed at the meeting today that when I asked for a summer program, I was informed that the district is low in their budget this year, and unfortunately I've already met the cutoff, and my child can't receive summer services because the budget's too tight. And my understanding is that that's not permitted under the federal law, and I want to make sure that we address this. Please get back to me. Putting those things in an email is important because it doesn't always make it into the record in the way that we would like when the documents come back from the meeting.
Right, exactly. And we have a question from Melissa. So let me see. She says that she was told by her daughter's vocational technical high school that if she brought an educational advocate, that they are allowed to bring an attorney, which I never heard of before, because I use an educational advocate at my son's IEP meeting, and the schools never brought their attorney. Is this true, or is my daughter's school confused?
Well, let me address this one.
Take a stab at that first, yeah.
I can't say whether they're confused or not. That I would need to know a lot more about. But what I can say is that it is legally permissible for a school district to have an attorney there when the parent has an advocate, and even if the parent doesn't have an advocate. So they are within their legal rights to bring their attorney if the parent brings an advocate, and even if they don't, if they feel that they need legal advice. There is only one meeting under the federal law where the district is not permitted to bring their attorney unless the parent has one, and that is something called a resolution session, which is a meeting that only occurs once a parent has filed for a due process hearing. And according to the statute, if a parent files for a hearing and a resolution session is convened and the parent does not have counsel, the district cannot have counsel. Other than that, surprisingly, at IEP meetings, you'd be amazed how often this question is asked, because there are many districts who, as a matter of course, if a parent is going to bring someone like Julie, who's a seasoned advocate, they'll bring their lawyer. And sometimes just if it's a parent that has made it clear that they're exercising their rights, or for whatever reason is perceived by the school district to be someone that they need to have legal advice regarding, they can and will and sometimes do bring their lawyer. Now, there are ethical questions, and this is a question that within the community of parent attorneys and advocates we talk about fairly frequently, about what role the board's attorney can play in that IEP meeting, and whether or not that attorney might be putting themselves in a position where they may be a witness, especially if the parent is not represented by counsel. And there are some legal ethical issues that surround that. But what I would say is, as Julie and I like to do, cutting through the fog of all of that legalese that I just shared with you is this. Yeah. If you're a parent and you're going to a meeting with your school district and they have a lawyer and you don't, you should be very concerned and be thinking about whether or not your advocate is one that knows when to tell a parent it's time to bring in a lawyer, which is essential for a good advocate, is to know this case has now reached the point where this parent is being really underserved unless they also have counsel.
Right.
But going back, I'm sorry.
No,
going back to relationships, you're going to have, or you should have, a heads up that the attorney is coming, because that attorney should be on the invitation. If the attorney wasn't on the invitation, clearly that's one way to say, I'm not comfortable having the person at the meeting because they weren't on the invitation. But let's say the person was on the invitation, you didn't read it, or you did read it. That's where perhaps you can pick up the phone to your director of special education and say, can we talk about this? I will also often help parents write an email that says, I'm very uncomfortable with this imbalance. I have an advocate, you're bringing in your attorney. Are you suggesting I bring an attorney? And again, going back to relationships, the way that you approach that person may often convince the director of special education to say, you know what, it's making you uncomfortable, I'm not going to go there yet. But again, that's where you can reach outside of the box, go outside of the lines of the IEP team meeting itself and speak to someone and say, this isn't really making me uncomfortable. What's your motivation behind it?
Oh, exactly. And we have Roxanne from Colorado, and Roxanne says, hello. How do we get unburied from being intentionally buried by the district after winning a state complaint? We have 3 special needs kiddos with very unique needs. The district knows this and seems to be making things very complicated and confusing, and a lot of work for us as we try to move forward and ensure fate for our kiddos. It also seems like they are trying to build a due process case against the complaint win.
Sounds like a complicated situation with with several children. And a caveat, essentially.
Fog, a lot of fog.
Yeah, lots of fog, right? What I can say is this: it is unfortunately not unheard of when a parent does exercise their rights through either a complaint or a due process hearing for their district to retaliate. We have a chapter called intimidation, coercion, retaliation, oh my. I don't want people to come away from this session thinking it's the norm. It's not. And we caution parents, please do not throw the word intimidation, retaliation, or harassment or coercion around unless you have absolutely strong evidence to prove it, because that's not something you should be levying against your school district or frankly anyone without evidence. But it does happen. And so I would say that, there's too many particulars here that I would feel uncomfortable feeling like I know how to even help a parent where to start, other than that if they haven't already, maybe they want to be joining COPA, which is the Council of Parent Attorneys and Advocates. It's COPAA.org. Julie and I are proud members, and I believe you too. And we always tell parents who feel overwhelmed by being in the middle of a process or perhaps where they're being intimidated to join the organization, not just because of all the resources that are provided at the conference and to members, but because they have a very valuable listserv for parents to ask questions, and many advocates and attorneys even stay on that listserv and try to answer them. So maybe it's a good time to talk to somebody a little closer to where you live, who might be able to point you in the right direction. My only cutting through the fog other than that, which I don't want it to sound like I'm pushing off the question, but I also don't want to be giving legal advice when I'm not in a position to do so to somebody without having looked at all their records and being in a position to advise them. I think it's important just to know that if your instinct as a parent is that you're being targeted in some fashion, you probably are.
Right. And I would add to that, we have a chapter also called Best Kept Secrets, and there are lots of resources available to parents. As an example, Jen mentioned COPA, but there's also the Protection and Advocacy, which is in every state, parent training information centers. They're called different things in every single state. There is, what else, Jen? We've got, but those are the big ones, P&A and the Parent Information Training Centers in your state that, parents should be encouraged to reach out to those agencies or organizations within their state and ask, gee, what should I do?
Yeah.
Right. And I think, maybe with Roxanne, because she's also, I know a little bit about the backstory, but I think not only is it that feeling like, because you won the state complaint, the district is going to find some way to kind of twist the knife in your back or something and make you feel a little bit of pain, but also just the stress and the paperwork of having 3 kids and just trying to keep things organized and clear. So I don't know if either of you have organizing tips, because, I think when I was advocating for my son, I had a ton of notebooks with documents, and I can't imagine what it would be like for 3. So do either of you have an organizing tip for parents on how to keep track of all that paperwork?
Well, if I could answer that question, maybe not particularly directly as you asked it, I like to say to parents sometimes, keep it simple, stupid, the KISS methodology, right? That sometimes you can go into an IEPT meeting and there are so many things that can be done to improve the program. But if you don't get some overarching issues resolved, none of the things that can fall down from that big decision that's made can happen. And so to really be thinking of an IEP as what are the big takeaways that we have to accomplish, because it's almost impossible to accomplish 20 things at an IEPT meeting, and really boil it down to what are the essential things you need to get out of a meeting. And oh, by the way, you might need to have another meeting. I think obviously it's challenging to have one child who has a special education need. Again, this is where we have a chapter in our book called Finding Your Advocacy Style. And quite frankly, we have parents who come to us and say, I can't do this. And that's where we encourage you to join COPA. find and go on the list and see, is there an advocate in your state who you might want to start working with? Can you get some help from a parent, one of the parent information training centers or the PNA? It is overwhelming, and sometimes there's no magic around that. You need to, perhaps some people need to get some help. I don't know if that makes sense, but
Yeah, that's really helpful. Yeah, because I think that's true. I mean, when I talk to parents and they want me to attend meetings, one of the questions I'll ask is, what do you want to see as outcomes from this meeting?
right,
Because,
that's exactly what I ask.
we want to know what we're shooting for as far as our
Right.
aim and our target. And you're right, you have to prioritize because, an hour or an hour and a half is very challenging to get a well-written IEP in place. So expect that you might have to ask for a follow-up meeting, another IEP meeting to complete it. But I think to prioritize, always have that big vision of where you're going for your child and knowing that each IEP is supposed to be one step closer to that big vision you have,
Oh, and just from a practical standpoint, I mean, clearly from an organization standpoint alone, you've got to have 3 binders, right? But one of the things that I always ask school districts now is, can you send us your documents electronically? And because so many people do everything on the computer, you can have separate files for each child. But anytime that you can scan the documents and keep it all electronically, people have to find an organization system that works for them. But the bottom line is, it's overwhelming.
Oh, exactly. So we've got more people live with us. I want to see within the next few minutes if we can get more comments and your take. So Kathy says, is it helpful to bring someone like the director of the Habilitative Intervention and Supports Program that my child works with to come to the IEP? I feel like I'm going to go into this completely alone, and I want to make sure my son is getting everything he needs.
Okay, so a parent is legally entitled to bring individuals who they believe have knowledge about their child with them to the IEP meeting. And many families will do that. And there are many circumstances where it makes sense to do that. If your child's receiving services from an outside agency or a private therapist, there can be great value in asking them to attend the meeting, not just the psychological value of not feeling like you're on your own, but many times children present differently in school than they do outside of school, or there is a fundamental disagreement about whether the child requires a certain service or support, and to have some outside person there to say, no, I know you're saying that you're not seeing Billy inattentive in your educational environment, but the parent's saying that he's always inattentive, and I can tell you when I'm with him for one-to-one in my service room outside of school, he's extremely inattentive. It can be validating as a matter of evidence, as a matter of feeling like you're not alone. There are times where it makes really good sense to do that, and there are times where it doesn't. And some of the answer to that question can be financial. Some of these people will charge you to attend the meeting. Professionals often will expect to be paid to be there. Not all. Many professionals will go because they want to help out with the family, but many will expect to be paid for their time. And if you invite them, you're expected to pay them. And so in a time where everyone has to be looking at their resources, you might want to see that person might be able to submit a letter instead, making their recommendations known to the team and the current status of the child across domains in terms of how they're functioning. You want to make sure that anyone who does something like that, puts that in writing or attends the meeting, frankly, has some familiarity with the process. And I say that because many of my clients have complex medical profiles and they have a lot of doctors in their lives, and they may be the world's greatest surgeon or doctor, but you get them into an IEP meeting and they say 4 or 5 things that make my stomach cringe because we know they're the hot button. Don't say that, please. Things like, I want this child to get this because that's the best education that he can get, which parents are not legally entitled to the best education publicly. They're entitled to an appropriate education. Thankfully, that means something more today than it did a few months ago with the Supreme Court decision, which you and I have spoken about, Charmaine. But ultimately, you want to make sure that there's someone who understands this process. And so I've seen cases where I've inherited the file and there have been some disasters because an outside person came in who just didn't know they were saying all sorts of things that were terribly unhelpful to the case. So, again, it's a case-by-case analysis, but if you feel like that person knows your child or knows some important aspect of their program and you feel that you're not in a position to express it and or they're willing and able to do it, absolutely have at it.
Great. And then Kelly has a question here. So let me see. She says, I tried to educate a school district on specific learning disabilities such as dysgraphia. Sent information to a general ed teacher. It did not work whatsoever. The only thing that worked was sending them a court case from Virginia under Wright's Law.
Is there a question in there?
No, so I guess, so that's a comment, but I think it goes back to what we had said before. If you can find some kind of authoritative document or a reference or resource that you can bring, that shows the district that this isn't just you asking for this for your child, but you do have a basis for making your request.
Yeah.
Right. And
going back to what, go ahead, Julie.
Okay. No, I said, going back to what you said, it's all in how you present the information, and you don't want to, approach is everything, right?
Yeah. Yes, it is. But here's a handy little tip that Julie and I will give parents, not just in our book, but we tell parents this a lot when we present. If you, short of bringing in cases and OSEP, which is the Office of Special Education Programs, just to break that acronym down, OSEP letters or that kind of legal guidance, you can let your school district know pretty quickly that you've done your homework by just asking that what you've requested be reflected on prior written notice. There's a whole chapter in our book that talks about various things of this nature and procedural safeguards and talks about prior written notice, but it's a part of the IEP document that where a parent's requests must be documented, whether they're refused or proposed. And that alone, I found, makes a team take notice, and they think, oh, this parent actually maybe has done their research. It's a little simpler than coming in with a case.
That's true. And like you said, you don't want to come in with the case and then they say, but look at this point. And it's like, you don't know what, so I think it is better to be safe. I know I was at one school for several meetings and I kind of was the broken record of, so can you document that in the prior written notice? I mean, the special ed teacher was getting very annoyed, but it was like, we're not going to let this slide, It's like,
well,
so, but so many times I think people, both parents and teachers, don't realize the value of that prior written notice.
In fact, we wrote a whole chapter about that too. And, how many times does a parent say to me and Jen, well, I asked for it at the last meeting, and we will look at the documentation and we'll say, well, you may have asked for it, but it's not recorded. So therefore it didn't happen. So again, why did we write a chapter on prior written notice? Because it's probably not one of the things that a school district is going to tell you. Oh, by the way, make sure you ask us to put what you requested on prior written notice. And so while our book is very narrative and we use a lot of we try to, be light and use some wit because, hey, this is heavy stuff. Let's just face it. But a lot of, while we don't go into every single aspect of the IDEA, and we do a lot of that on our yourspecialeducationrights.com, we do hit some of the heavy hitting things that parents need to know. For example, their right to an independent educational evaluation and what prior written notice is, because those are sort of cornerstone concepts of the IDEA that if you don't know about that, it's sort of that big overarching thing that you need to have so you can do all the other stuff.
Right. Oh, exactly. And another parent has said, it seems like if the child scores well on testing materials, as far as intelligence and grades are concerned, it's harder to get other types of emotional and social support through the school system for said child. We are in Virginia. Are there any emotional social tools and programs within the school system that could benefit our children that the schools don't tell us about?
Yeah, so Julie and I have many of our mantras too, and one of them is education is more than just academics.
Yeah.
And that's something that we want you to just keep in your mind at all times, because there are children who do really well on standardized testing who still require specialized instruction and who still wouldn't function in this world without specialized instruction and special education. And there are many curricula out there for students on coping skills, social skills, and I'm not an educator, but there are many programs that provide therapeutic intervention for students who may require that kind of support. What we want parents to know is that they shouldn't get sucked into the fallacy that just because a child is able to perform well on some standardized tests and even sometimes get good grades because they may be off the charts in their intelligence. But, if a kid is a straight A student but has missed, 45 days of school that year because they don't have coping skills and they're anxious, or they're struggling with depression, or they don't have the social skills to know how to interact with their non-disabled peers, that child very well may require an IEP. And so education is more than just academics is what we want you to take away from that.
Right. And I'd sort of like to flip that question that person asked, what can the school district offer? That's where I go back to the parent has a right to ask for the child to be evaluated in that suspected area of disability. So the evaluation can make recommendations. Those recommendations become the basis of requesting the very thing that evaluation made recommendations about. So you can't answer that question until the child has been evaluated in that suspected area of disability.
Oh, yes. And Tasha from Texas, she says, looking for advocate for my child's school district in Kendall, Texas. And so I know, Tasha, both the COPA website, which if you just type in COPAA, you can get to their website. They have a directory of both advocates and attorneys by state, or Wright's Law has the yellow pages, which again gives a state by state, list of advocates and attorneys. And most likely your Parent Training and Information Center, if you call them, they will be able to tell you about local advocates. And Tasha, I'll look up where you are in Texas, and I'll come back after the video and I'll give you the name and number of the Parent Training Center for your area in Texas, and we'll make sure that you get hooked up with somebody.
Let me add to that, Charmaine. Texas, we're very fortunate. Texas is a state where we have a very strong presence of advocates and attorneys. And I believe there is an organization in Texas called TOPA, which is the Texas Organization for Parent Attorneys and Advocates. So you might want to look that up too.
Yes, that's true. Yeah, they even have their own conferences and do awesome things down there in Texas.
Yeah.
So, well, we're coming up to about an hour being on live, and I just want to thank both of you because your wealth of knowledge and insights is like so valuable, and I'm so excited that it's now in a book that parents can grab hold of. And sometimes even taking books like this to the IEP meeting with you can be a subtle way of, I think I've done my research. So, but I want to give both Jen and Julie a chance to say any final words, and then we'll wrap up our show.
Oh, goodness. Well, thank you very much for having us on. We're thrilled that the book is being received so well. And for those of you who have ordered it and it's still on back order, we really are hoping that you'll have your book within a week or two. One of the people who I know have been waiting just let me know yesterday she got hers yesterday. So I'm hoping that the reprint is going to be forthcoming really quickly for everybody. So thank you for that. And just that we feel so strongly that knowledge is power. And as much as you can do to learn about your child's rights and to learn how to apply them, we hope our book helps you do that.
Thank you.
And I would say that, the parents are the primary enforcers of the IDEA, and there's no one waiting in line behind you to advocate for your child. And if there's anything in life worth fighting for, it's your child. This is a very overwhelming law. It's a complicated landscape. Jen and I try to simplify it through our website, yourspecialeducationrights.com, and cut through the fog in this book. And we hope that it's something that could help parents really have a good grounding on understanding how to navigate this system.
Oh, exactly. And I'll put the link to Jen and Julie's websites, yourspecialeducationrights.com, in the description of the video, so people can go and check out their short videos that just give you that, bam of information that you need when you need it. But I also want to remind my viewers that we're always here every Thursday at noon Mountain Time. Next week happens to be the 50th show that I've done on Facebook Live. So I've come up with some crazy surprises that we're going to have happening next Thursday, and some gifts of gratitude for parents. So make sure you tune in next week. And I just want to share my passion, and I know Jen and Julie's passion, that we are here to help make a difference for kids, for your child. And we want to be that support person that can make sure that you're even a more effective advocate. So your child is safe, happy, and learning every day at school. So together, that's what we're going to be doing in this country, in this world, right? So until next Thursday at noon Mountain Time, everybody have a wonderful week and take care.
Thank you, Charmaine.